So in one sense, what I'm presenting today is very preliminary in its very early stages. But in another sense, it's something that I've just recently realized I've actually been thinking about for a very long time and only found a way to express by returning to a book of essays by writer, feminist, and activist Audre Lorde. So I want to talk a little bit about that essay and then explain its relevance. In her essay, "The Master's Tools Will Never Dismantle the Master's House," Lorde critiqued the lack of inclusion at a women's conference she was invited to speak at. She wrote, "As women, we've been taught either to ignore our differences or to view them as causes for separation and suspicion, rather than as forces for change. Those of us who stand outside the circle of this society's definition of acceptable women know that survival is not an academic skill. It is learning how to take our differences and make them strengths. For the master's tools will never dismantle the master's house. They may allow us to temporarily beat him at his own game, but they will never enable us to bring about genuine change." So what, you may ask, has this to do with a conference on IP and trade? Audre Lorde was indeed talking about a very different issue. She was talking about the failure of straight, white, feminist academics to embrace difference in their work, to see difference as generative rather than as a chasm they could not cross. Lorde is arguing in this passage that part of the reason for this failure is that her audience had bought into the idea embedded in systems of oppression that difference is something to be feared. She was arguing that the master's tools, namely the logics of the oppressor, can never be used to dismantle that oppression. Now, I do want to apologize briefly for doing a disservice to the power of Lorde's words by applying them to something as mundane as intellectual property. And I also perhaps should apologize to intellectual property for comparing its rules to a hegemonic system of institutionalized oppression, although perhaps I might still do that a tiny bit. But I do think for me, reading this passage helped me see more clearly the extent to which I've been challenged by discussions about human rights and IP since the very beginning, because I feel that human rights playing by IP rules will never realize its full potential for change. So much ink has been spilled over the relationship between these two regimes, whether they are the same, whether they conflict, whether they can coexist and pursue the same goals, or whether maybe they're even systematically in tension with one another. I argue that it is none of the above. I think that they're fundamentally incommensurable. They have no common measure. It is more than just a difference in orientation. Although human rights and intellectual property both adopt the form of legal rules, these rules are more different from one another than they are the same in terms of the way that they're created, the manner in which they're interpreted and enforced, what they seek to measure, the metrics they use to identify progress, the values they embody, the logics they exhibit, the role played by ambiguity, to name just a few. The second point I want to make is that even more problematically, the very process of trying to reconcile IP and human rights limits the transformative potential of human rights to affect change. So to borrow from Lorde's logic, again with apologies, IP rules will never dismantle the IP house. IP rules may allow us to temporarily beat IP at its own game, but they will never allow us, they never enable us to bring about genuine change. So let me talk about each of these two concerns in turn. First, the incommensurability of IP and human rights, and then the issue of dismantling the IP house. So I think that there's likely some level of incommensurability associated with any conflict of rules, and I used to teach conflicts, and so I think it is true both domestically and then particularly on the international level, right? There's a great level of fragmentation. I'd suggest, however, that the incommensurability of IP and human rights is particularly profound for a few different reasons. Yes, IP and human rights both share a common purpose in promoting human flourishing, but not really. IP norms create scarcity in order to incentivize innovation and protect and reward those who engage in productive activity. Innovation may be a social good that results from IP rules, but IP does not typically ask questions, the central human questions about what kind of innovation and who it benefits. It also commits the state to using this one type of tool, the market, to accomplish its goals. Especially in the last several states, this logic has been backed up by very strong neoliberal theories of economic development And this pre-commitment to this one particular type of tool has really crowded out and limited the ability of states to experiment with other ways of promoting innovation. International intellectual property rules also come with very strong institutions, powerful interpretive constituencies. It has a dispute settlement body and an appellate body. It has now investor-state tribunal arbitration. It has a very powerful set of actors that are extremely well-resourced and exceedingly devoted to enforcing their rights. While states sometimes chafe under the restrictions that IP might impose, they also do fundamentally see it as valuable and an important part of providing a welcoming commercial landscape. Human rights, in contrast, has no such institutions or constituencies, at least powerful ones, nor does it provoke the same sort of conflicted response on the part of states. Human rights are protected by international treaties that do create binding legal commitments, but almost always, though, those same important binding commitments are paired with extremely weak enforcement mechanisms. This means that human rights is systematically disadvantaged in conflicts between the two. So the second point, the dismantling of the IP house, I think that in not realizing the incommensurability of these two regimes, we've forced them to play with each other. And in so doing, we've limited the ability of human rights to affect change. We've attempted to use human rights as a set of legal rules that could be deployed to limit or complement IP legal rules. In doing so, we've implicitly subordinated human rights to IP logic. The result is that while there may be temporary wins, these wins will be limited because we've already ceded the rules of the game. So I want to give a couple of examples of how I see this playing out. So recently, I was part of a team that wrote a book for the World Blind Union providing an interpretation of the Marrakesh Treaty, and the full name is the Marrakesh Treaty to Facilitate Access to Published Works for Persons Who Are Blind, Visually Impaired, or Otherwise Print Disabled. And I will only give you the full title once. We'll just call it the Marrakesh Treaty. This is an international agreement negotiated under the auspices of WIPO that requires states who ratify the treaty to create mandatory exceptions to copyright for the benefit of individuals who are print disabled. So that individuals who are print disabled, instead of having to ask permission from the copyright owner to create a Braille version of a book to make the text larger, among other many kinds of things that would otherwise be a copyright violation, they can simply do that. So the idea is to create access to published works and to try to eliminate the book famine for individuals with print disabilities. As part of that book, we had to confront the three-step test, which we've already discussed, which appears 5 times in a treaty with only 22 articles. So indeed, the folks who were negotiating this treaty were very anxious about the test. So we argued that the treaty defines exceptions and limitations to copyright that are presumptively compatible with the treaty. If states created exceptions and then had to further justify them as compatible with other international treaties, that would defeat the very purpose, object, and purpose of the Marrakesh Treaty. So we argue that both based on the treaty itself and other arguments, these are prima facie compatible with the three-step test, the pathways that are articulated by the Marrakesh Treaty. We explain that the test, the three-step test, in the course of this, we had to talk about the three-step test's compatibility with human rights. And we argue this test demarcates the policy spaces within which states may legitimately enact E&Ls, to, exceptions and limitations to the exclusive rights of copyright holders. So the three-step test creates this space. We argue that it serves a dual purpose, not only to safeguard the rights of copyright holders, but also to protect state discretion to regulate these rights in ways that meet social or cultural needs. So we argue that they're not only permissible restrictions, they're not only exceptions and limitations that are consistent with the test are not only the permissible restrictions on copyright, they're affirmative expressions of government policy pursuing desirable social ends. So I think this was, as I was writing the book, the most human rights compatible explanation of the three-step test possible. The three-step test in this view mediates between the two legal regimes ensuring that states can apply copyright law in ways that protect human rights and guard against copyright abuses by copyright holders. Nonetheless, it was deeply unsatisfying. First, I don't think it's a widely held view of the three-step test. So again, it's one of those arguments that I think can be made, but may or may not necessarily always be taken up by those with the authority to issue authoritative interpretations. Second, I think it subordinates the primary question asked by human rights norms to the protection of the economic interests of rights holders. It asks whether human rights fits into a system designed to protect those economic interests, rather than asking how the economic interests fit into a system designed to protect the rights of individuals. Then, further, because of the strength and specificity of IP law compared to human rights, those human rights law obligations are now obligated to fit within the narrow parameters reserved to them by the three-step test. I think a second example came up this morning when I asked whether you could justify regulation to protect human rights only if it were unsuccessful. That if the regulation were actually successful, perhaps it would in fact be an expropriation. I am persuaded by the policy arguments that this is a regulatory exception, that human rights arguments could be used to support police power to regulate, to protect individuals. I don't know if, again, those will widely be accepted. Having watched ICSID arbitration over the necessity exception when countries tried to argue in favor of regulation designed to protect individuals, international economic institutions, international dispute settlement bodies tend and did in that case adopt fairly narrow interpretations. The fear of big interpretations, of big exceptions, is that they will swallow the rule, that they will be used and exploited by states to engage in protectionist activity. My point is, human rights wants that protectionist activity, not necessarily to protect domestic industry, but to protect, to protect people. So what is a new vision of human rights? And I want to leave some time for questions, so I'll try to go quickly through this last piece. Should WTO panels interpret human rights rules? This is one of the questions asked by the organizers. I think the answer is they will, they can, but should we encourage it? I'm not sure. Human rights is at its weakest, in fact, when it's viewed as a set of technocratic doctrines of the same nature and balance as IP rules. Human rights are at its weakest when you ask, how do we balance this with the economic rights of rights holders? How do we reconcile them? How do we integrate them? We can, in fact, and I think should, make these arguments selectively, but we need to be cautious about the extent to which meeting IP on its own terms has a tendency to cede the fundamental terms of the debate. Human rights are legal rights, but they are legal rights of a particular type. They are legal rules that provide a vehicle for the assertion of political demands. So although couched in the language of the law, human rights is instead a set of rhetorical strategies designed to be used to make demands for political change. I think that we can use human rights as a framework for those demands, and I argue in favor of demanding human-centered innovation. I think that this includes two elements. I think first, we need to look at innovation. We need to found it on a policy of anti-subordination. So I'm taking this from anti-discrimination law and theory in the US. Anti-subordination theory argues that guarantees of equal citizenship cannot be realized under conditions of pervasive social stratification. I think similarly, human rights has to address the importance of dismantling fundamental social stratification and inequity that is embedded in our innovation systems. Human-centered innovation requires an enabling innovation environment to promote and fulfill human rights, and it can provide a vehicle for activists to pressure the state to reform both national innovation policies and international trade rules to ensure greater global justice. And second, I think it means we have to think about substantive equality in a global sense, not a national sense. States have to consider not only how their innovation policies affect the rights of those within their jurisdiction, but also how they impact the rights of individuals outside and in other countries. This is in part because of the requirements of international human rights law, which I will talk about in the paper, but not here. But I think this global focus is also of particular importance at the current moment. Trade is faltering in part because it has manifestly failed to deliver on promises of prosperity for all but the very few who are already at the top. The solution, though, I think, is not to double down on nationalism and protectionism. We are far too independent for that to be a successful strategy. Rather, we need to make the case for systems of innovation that are designed to promote the welfare of all. And I think human rights can be the vehicle for doing that. Thank you very much.